New at 6, civil liberties advocates say a DNA test during an arrest amounts to an invasion of privacy. But the ruling upholds a law that voters first approved in 2004. KPIX 5 political reporter Melissa Caen is live for us in San Francisco with the relief and concerns over this new rule. Melissa?
Yeah, Veronica, we're here at the California State Supreme Court, where earlier today judges ruled that just like fingerprinting, when a person is booked for a felony, they have to give over their DNA and let it be run against a national database.
I feel beyond words relieved.
Ashley Spence has been following this case very closely. In 2003, she was about to start her sophomore year at Arizona State University.
And in the middle of the night, I was asleep, and someone had intruded in my apartment without me knowing. My face was covered the entire time. I was awoken to someone raping and assaulting me.
In 2004, California voters passed Proposition 69, which requires any person arrested for a felony to give their DNA. It's then run through a nationwide system to see if there are any matches. In 2010, Kevin Lee Francois was arrested in California. His DNA matched Ashley's case, and in 2015, he was sentenced to 138 years in prison.
I know that without that law, that my attacker would most likely be out there still harming other people and women.
Jennifer Lynch is a senior attorney at the Electronic Frontier Foundation. She says taking the DNA of anyone arrested for a felony can be unfair. For example, in domestic violence cases.
Law enforcement officers come into a domestic violence situation and they can't tell who is responsible, who is the person being violent, and so they just arrest both parties. And that would mean that people who are the victims of crime, they have their DNA put into the state's arrestee database as well.
She says the biggest problem with the current system is that it does not automatically delete the information of people who are not convicted.
That means that the nearly 1/3 of arrestees who are never found guilty of any crime, their DNA remains in the state database. It's very difficult to get that DNA taken out of the state database.
Now that the case is over, the foundation is looking to change the law so DNA would automatically be deleted if a person is not convicted of a felony.
The legislature has already looked into changing the law, so I think that's something that we'll push going forward.
Now, this is really the end of the line for this issue for now, at least. This is the state Supreme Court interpreting state law, so it can't be appealed to the U.S. Supreme Court, for example. Veronica?
Oh, Melissa, obviously there are two sides to the debate here. So is there a way to get your DNA out of the system?
Well, currently there is a way to do it, but according to Ms. Lynch, it's very difficult. There are specific time frames you have to do it in. You have to get the prosecuting attorney to sign off on it, and the state does not offer legal assistance to people trying to go through the process. So the option is there, but it's unclear exactly how many people get to take advantage of it. Veronica?
All right, Melissa Caen, we appreciate that. Thank you.